afterwards, we will listen to experts from Great Britain, followed by our Malaysian colleagues. Then we will hear about the situation in Germany. And last but not least, we will listen to our experts from China. The reports from each jurisdiction will be followed by a short Q&A session. And therefore, I encourage all attendees to put forward their question in the chat function, which you can also find on the right side of your Zoom window. And I will then put those questions forward to the speakers, and I'm pretty sure the speakers will do their best to answer your questions. I also kindly remind the speakers of today's session, when it's not their turn to speak, please mute your microphone to avoid any background noise. And now we already will start. And I invite President Chung-Hwan Choi from LAWASIA to give his greeting remarks. Chung-Hwan, please, the floor is yours.
Thank you, Svetlana. Good afternoon from Seoul, Korea. It is my great pleasure to welcome you to today's webinar. I would like to thank the co-organizers of this event, the German Federal Bar, for assisting with the preparation and for administering today's webinar. My name is Chung-Hwan Choi, and I am the president of LAWASIA, the law association that represents thousands of lawyers in Asia and the Pacific region through its organizational members, which comprise legal organizations, including bar associations and law societies from over 40 jurisdictions. Our mission at LAWASIA is to enhance the knowledge and quality of practice of lawyers within the region through legal education and training. LAWASIA and its organizational members collaborate to solve challenges facing our members and to provide a platform to share knowledge and idea. We encourage as a central objective adherence to the principles of rule of law, access to justice, and the protection of human rights. Although LAWASIA's focus is mainly on Asia and the Pacific region, we also welcome individuals and legal organizations from across the globe who have an interest in Asia and the Pacific and who seek opportunities to collaborate with Asian lawyers and bar associations in Asia. LAWASIA plays a pivotal role in building networks of like-minded lawyers from across Asia and Europe and providing a platform for lawyers and legal organizations to collaborate, connect, and develop mutually beneficial relationships through its Asia-Europe Committee. We are grateful for the work of the chair of that committee, Mr. Henning von Zantiel, who is the moderator of this webinar. Today's unique webinar will provide us with the opportunity to hear about some of the innovative measures governments from across the globe have developed to address the impact from an economic perspective of the COVID-19 pandemic and to mitigate or prevent a decline in their respective economies. It will no doubt be a useful reminder to us about the challenges many of us face and to learn from the experience of our colleagues. I again thank the German Federal Bar for co-hosting this event. I also wish to personally invite each of you attending today's session to consider becoming more involved in LAWASIA and learning more about the unique opportunities LAWASIA membership provides. Thank you very much.
Thank you, Mr. President. And I can say from my own experience, it's really a great pleasure to be with LAWASIA, and the work with LAWASIA is a unique opportunity. So I also encourage people to become a member. Thank you very much. And now I would like to invite Dr. Christian Lemke, Vice President of the German Federal Bar. Please unmute your microphone and give your greeting remarks.
Well, thank you, dear President Chungwan Choi, dear experts, dear participants of today's webinar. A warm welcome to all of you on behalf of the German Federal Bar. Good morning from Hamburg, or good afternoon. The crisis has now been holding the world in its grip since the beginning of 2020. Now a year has passed and life has not yet returned to normal. At least that is the situation here in Germany. Despite the situation, it is important to reach out to the global legal community for exchange and discussion. Therefore, I would like to thank LAWASIA for organizing this joint event with the German Federal Bar on this very important topic. Allow me to shortly introduce our organization, the German Federal Bar. The German Federal Bar is the central representative of the legal profession in Germany and the umbrella organization of the 28 regional bars. With 167,000 lawyers, the legal profession in Germany is one of the largest in Europe. We have a system of compulsory membership. This means that every lawyer in Germany must become a member of the regional bar in order to be able to practice law in Germany. And the German Federal Bar represents the professional interests of the entire legal profession in Germany at the federal, European, and international levels. We've been committed to the development of the legal profession and the rule of law in Germany and other countries for many years. As globalization progresses, our international activities become more intensive. To date, we are heavily involved in our international affairs on the legal profession worldwide. Our activities are steadily increasing, with our most recent activities being in the North African region. Nevertheless, a significant focus of our international work remains in Asia, as we believe that the development of advocacy in Asia will increasingly influence developments in Europe and vice versa. For this reason, we are involved in LAWASIA and strive to continuously deepen our relationship and expand our network. The work and goals of LAWASIA are very compelling in our eyes, namely the goals of protecting human rights, promoting independent advocacy in the region, and supporting the rule of law. The German Federal Bar shares all of these values and goals, and we pursue them through our work at the national and international level. Therefore, cooperation with LAWASIA and its members is of utmost importance to us. The topic of today's webinar is state measures to save business during the pandemic in Asia and Europe. We will take a look at 4 different jurisdictions and have the chance to compare the situation. I'm looking very much forward to it, and I wish all participants an interesting and pleasant event, and I hope that more will follow. Thank you.
Oh, I'm sorry, I had to find my unmute button. I have 3 screens here, so this sometimes happens. Thank you very much, Christian, for these warm words. And now I would like to invite, last but not least, the chair of the Asia-Europe subcommittee of LAWASIA, Henning van Santier, to give his greeting remarks. Henning, please, the floor is yours.
Thank you very much. A warm welcome also from the Asian-European subcommittee. Good afternoon for the Asian members and participants, and good morning for the Europeans. The idea of this topic was that we found out, being involved in Asia and Europe, that there's a big difference in numbers of what the pandemic is doing with us. And so I give you one slide to show you this difference. First of all, you have the total state funds, and the green is some selected countries from the LAWASIA region, and the blue area is the European, some selected European countries. There you can see that the most money was spent so far by Germany with 890 billion US dollars, followed by China with 500 billion US dollars. But if you break it down to the inhabitants, 1 million inhabitants, then you can see that in the European countries, much more money is spent per million inhabitants. We talk about the billions, whereas in the LAWASIA regions, only millions are spent, and we are talking the least is Vietnam with 11 million per 1 million inhabitants. So if you see these figures, you would think, well, so much money spent in Europe fighting the pandemic, so it should have more effects. But the opposite is true. So if we come to the total figures of death, India has the lead with 160,000. But the least have Taiwan with only 10 killed altogether in the whole year, followed by Vietnam with 35 people killed. These figures are somehow misleading if you don't compare to per million inhabitants, and then you will see that the maximum is India with 118 killed per 1 million inhabitants, but Europe is in the thousands, having the lead by Belgium with 2,000. So you could think this is 1 year has passed, so maybe now it's getting better because of the vaccination, and maybe because Europe has spent so much money, the vaccination is giving Europe better figures. But this is not the case. The lead again has India here with 1 million infected within the last 7 days, counting from the 22nd of March. But then we see Taiwan having here the lead with the least killed, with the least infected, sorry, with 1,000. Here again, this is the LAWASIA region is in the hundreds, whereas Europe is in the thousands. The lead has here United Kingdom. We're having a very good vaccination campaign with 5,700 infected within the last 7 days. And the EU, other than that, is in the 10,000. The lead has here France with 33,000. So these figures are for everybody in our subcommittee quite compelling, and we had quite discussions among our members. And so we thought this is a good reason to talk about it. What measures have been taken in the particular countries? How can we be actually in the end better in Europe, or how can we have the benchmark and the system to better deal in the future with the pandemic? It's good, of course, for one country to be having the lead, having less money spent, having less killed people, having less infected. But in the end, it's a global pandemic. So if in one region of the world the pandemic is still true, then is still vibrant, then the virus can mutate, and then it can infect all the other regions. So it's in our all interest to have a good defense on the globe against the pandemic. Also business-wise, which is maybe more interesting for us lawyers, it's not good if one region is behind and is somehow excluded from business. So we were asking for the reasons, and there are different reasons. I leave this for a hot discussion, hopefully after this session. First of all, as lawyers, we like to see the facts, and we like to have an overview of the figures in 4 countries. We are happy to have 2 countries from the LAWASIA region and 2 countries from Europe, and then have a discussion what we best can do against this pandemic. I wish you all a very interesting and also maybe to some extent inspiring webinar and a good discussion afterwards. Thank you very much.
Yes, Henning, thank you to you for your greeting remarks. It was a nice introduction to kick off straight away with the topic. So you showed us an overview about the statistics in different jurisdictions, and we will now turn to the jurisdictions one by one. And yeah, we will start with our first expert panel from Great Britain. We will hear about the situation in our neighboring country from Julie Edmonds, head of the Employment Law Department of the London-based law firm JPC. And Julie, a warm welcome. And we will also hear a presentation from Nitin Chauhan, partner of JPC law firm. Nitin, hello, nice to have you with us. Please, the floor is yours.
Thank you, Lana. I will start by sharing my screen, and I hope that everybody can see this. Great. Hopefully everybody can see that, and thank you again to LAWASIA and the German Federal Bar for organising today's seminar and both giving myself and Julie an opportunity to speak, to share the UK's perspective on the state measures we've adopted as a result of the ongoing COVID pandemic. By way of introduction, JPC is a full services London law firm with a commercial focus and an international reach. I'm privileged to be the firm's litigation and insolvency partner, but also the firm's international partner, whereas Julie is our head of employment, and we both act for clients within the UK and globally overseas, and that's even after Brexit. However, whilst we thought that what had happened at the end of 2019 was the UK's greatest challenge, it was nothing compared to the global impact of the COVID-19 pandemic in early 2020. This was an unprecedented event, and certainly one that many countries never imagined could happen in the modern society, and therefore never thought to prepare for. Over a year later, the virus has become part of people's daily lives and is a public health crisis in many countries. Whilst medical practitioners continue to fight the infection on the front line, others have had to consider the social and legal issues of the consequences they now face. But with no perfect legislative or policy response, that challenge has never been more difficult for governments, but also professionals like lawyers who are there to advise them and their clients, particularly business owners who have been crippled by interventions to halt the spread of the virus. Whilst the state measures taken are wide and diverse, during the course of this presentation, Julie and I hope to share the UK's approach to two key commercial areas of law, employment and insolvency. Now, let me hand over to Julie so that she may share more information with you about the UK government's support for businesses deployed for an employment law perspective.
Thank you, Nitin, and good morning, everyone. Thank you for having me today. I think it's safe to say that for the UK and for all countries around the world, last year has certainly been challenging for everybody, all businesses, and particularly for employers trying to manage the varying degrees of restrictions that have been introduced over the year. For some, this has meant a partial or complete closure of their business, and for others, it involves more of a remote workforce, where people are making use of technology that perhaps they'd never heard of, like Zoom, as we are today. And I think all of those measures have had an impact to varying degrees. What I'd like to do today is take you through some of the support that the UK government has introduced, and starting with the Coronavirus Job Retention Scheme, otherwise known as furlough. So the furlough scheme was announced on the 20th of March 2020, just before the first UK national lockdown. It was essentially the UK government's attempt to prevent widespread redundancies following the shutdown of a significant proportion of businesses. But what did this mean for employers as a whole? Furlough means that you keep your staff on payroll, so they maintain their employment with you, but they stop working altogether. And this may be because there is either no work or they can't perform their work at a workplace that isn't safe. The furlough scheme offered a government grant to cover 80% of an employee's wages and effectively preserve those jobs for the duration. It was initially due to run until June 2020, but has actually been extended 5 times since, which obviously has led to considerable uncertainty for a lot of businesses. Often there being criticism that the UK government has extended the scheme at the very last minute and made it very difficult for businesses to plan. So the scheme is open to all UK employers, regardless of size or sector. It covers 80% of wage costs. And that's something employers can decide to top up an employee's wages back to 100% of their normal salary. But the government grant will only cover up to a maximum of £2,500 per month for each employee. In July 2020, the government introduced the flexible furlough scheme, which allowed employers to bring their staff back to work on a part-time basis while still claiming a partial grant under the scheme for the hours that an employee wasn't able to work. Under the original job retention scheme, an employee on furlough was not allowed to perform any work at all for their employer. In September and October last year, the 80% was slightly adjusted and a contribution was required by the employer towards those costs. But again, the scheme was extended until the 31st of March. In the spring budget this year, on the 3rd of March, the Chancellor extended the furlough scheme again until September 2021 and reinstated the 80% of wages that were able to be claimed under the grant. As we go through the summer and hopefully as restrictions ease and businesses open up again, from July onwards, unworked hours will be paid at 70% with an employer contribution of 10%. And in August and September, that employer contribution will rise to 20%. So what has this meant for the UK government? The cost of the furlough scheme has been around £40 billion. And at the peak of the scheme, it was thought that there were over 10 million workers in the UK being paid effectively by the state. For an employer's point of view, this has offered a huge amount of breathing space to enable businesses to pay their employees at least some of their wages, and has meant that they can retain staff, which means once businesses open up again, they're ready and they can do that quicker. Furlough wasn't a word that anyone had heard of in terms of UK employment law before 2020, but it's certainly been a lifeline for all employers. So what about the self-employed? Under the Self-Employment Income Support Scheme, there was support offered to self-employed individuals who suffered loss of income due to COVID. This was opened in March 2020 and was introduced to replicate the government grants as part of the furlough scheme. To qualify for the self-employment scheme, you had to be trading in the last financial year, you had to still be trading, and you had to have annual trading profits below £50,000. This meant, and it was a difficult decision for government, but it meant that millions of self-employed were excluded from being able to access this scheme. If you were newly self-employed, you weren't able to claim the grant. If you were a director that was paid in dividends, this excluded you too. And if your trading profits were above £50,000, then again, you weren't able to access the grant. There have been 5 grants in total, and again, extended the same way that furlough has. So the grants cover a period from March 2020 until September 2021. To mirror the furlough scheme, the first grant covered 80% of your monthly trading profits, calculated over a period of the last 3 years. The initial grant covered 3 months of trading profits, up to a maximum grant that you could claim of £7,500. The second grant was calculated in the same way, but was limited to 70% of your trading profits rather than 80%. The third and fourth grant was back up to 80%. In the budget this year, as I've mentioned on the 3rd of March, the Chancellor confirmed that the self-employment grant would now be calculated based on the 2019-2020 tax year, which was a huge benefit to, it's estimated around 600,000 people who had been excluded previously. It meant that if somebody had recently become self-employed and had just filed their 2019-2020 tax return, they could now apply for the grant, whereas before, if you didn't have the 3 previous years trading, you weren't able to access the grant. So the 5th and final grant will cover a period between May and September 2021. The value of the grant this time is going to be calculated slightly differently and is based on turnover rather than profit. There are two elements to this part of the grant. If your turnover has fallen as a result of COVID and the pandemic by 30% or more, you will receive the full grant of 80% of your average trading profits, as in previous grants. Again, capped at £7,500 in total. If your turnover has fallen less than 30%, then you will receive a 30% grant capped at £2,850. The difference between the support available for employers, for their employees, and for the self-employed has really highlighted the differences in the UK between what benefits employees enjoy and the self-employed don't. For example, sick pay and holiday pay that self-employed do not have access to. As a result, there have been legal challenges in the UK over how the scheme is operated and who is and isn't able to claim. And the critics have said that it doesn't go far enough in terms of supporting people. There are some statistics that actually in October 2020, only 24% of self-employed received support under the scheme. And I think it's safe to say that as a result of that, the true impact on smaller businesses, those who are self-employed, it just remains to be seen while the pandemic is still continuing at pace. So what else has the government done in the UK to support employers? The furlough scheme and the self-employment income support scheme has certainly been the biggest support that's been offered for people. In fact, in April 2020, the government introduced a coronavirus business support finder, which is a web-based questionnaire designed to help businesses find out what schemes, loans, tax relief or grants they might be entitled to claim. And I think this is all to do with the spread of information and actually making sure that people are aware and can access the support that's out there. Some schemes that were originally planned to be introduced haven't been, as the pandemic has continued, which is not something I don't think anyone expected to last as long as it has already. For example, the job support scheme was intended to replace furlough and was a scheme that protected viable jobs. As furlough was extended, this scheme was postponed, but I think it's a real possibility that as furlough ends in September this year, if the effects of the pandemic are still there, then it may be that the job support scheme is resurrected. The other scheme again that was introduced and then shelved was the job retention bonus, and this was designed to reward employers for keeping employees on the payroll and bringing them back to work when they could. The idea was that each employer would receive £1,000 for every employee that they brought back to work from furlough and that was employed as of the 31st of January. Obviously, as the furlough scheme has been withdrawn, this hasn't been introduced, but it might be something again that is resurrected. Smaller support that employers have given, for example, statutory sick pay in the UK is generally available from the first day of absence. This changed due to COVID and now allows employers to pay statutory sick pay from day 1 rather than day 4, which is the norm, and allows employers who are small, have less than 250 employees, to get a refund of that statutory sick pay if somebody has 14 days coronavirus related absence. Another extension was the ability to carry over 4 weeks annual leave if an employee wasn't able to take that leave in the current leave year. Now this carries over to the next 2 years and is something that's completely at odds with UK law generally, because in the UK the rule is normally use it or lose it when it comes to holiday. So being able to carry holiday over into the next 2 years does change things quite significantly for employees. The government has also tried to incentivise employers to really try and engage with particularly younger workers who the studies have shown have been disproportionately affected by the job market and by redundancies. For example, apprentices would now be encouraged to join the business, and as a result of that, an employer will receive a grant of £3,000 for every new hire. There's also a Kickstart job creation scheme, which is again designed to help young people access jobs and get into long-term employment. The wages that they receive are covered by the government up to 100% of the national minimum wage, and there's also a grant for each placement that the employer makes. So a financial incentive for the employer, but also really important access for young people who may have been more so affected by the pandemic. So as we ease out of lockdown, the hope is that all legal limits in terms of social contacts will be lifted as of the 21st of June. Whether that will be the case, we don't know. But as workplaces open up, testing is going to become more important. Now, testing, I know one of the attendees has already asked a question about vaccine passports, but the same principle in terms of testing opens up a huge can of worms for employers in terms of either requiring staff to be tested and then what you do with that information. But I think as workplaces open up, it is really important because you have a duty as employer to look after your staff and to keep their health as much as you can. And therefore you can apply now. I think the cut-off is the end of March, so employers need to act quite quickly if they want to do that. But it does mean that they can get free tests for staff until the end of June, which I think is really quite significant. I'd now like to pass you back to my colleague Nitin, who will take you through some of the other business support measures and insolvency elements that the UK government have introduced.
Julie, thank you very much. That's very interesting. Turning to support under insolvency law in the UK, given the speed with which the virus took hold and the need to prevent the spread of infection, but most importantly to reduce the risk to life, the UK government swiftly imposed a lockdown like many other countries in both Europe and around the world. Of course, this not only had a huge impact on the economy, but on the livelihoods of many business owners, particularly small traders, sole traders, and small and medium-sized enterprises, also known as SMEs. However, to protect them from reprisal, the UK acted to help ease the transition into virtual life, and with respect to the risk of insolvency, a new temporary insolvency practice direction was brought into force on the 6th of April 2020. This introduced provisions related to the e-filing of certain notices, which importantly included notices of intention to appoint administrators, but also remote hearings, remote statutory declarations, and temporary listing procedures to give those business owners access to justice despite the restrictions surrounding them. Then, on the 26th of June 2020, the Corporate Insolvency and Governance Act of 2020, also known as CIGA, was introduced with the aim of lifting some of the pressures on distressed companies, specifically targeting those businesses where the cause of the struggle could be identified as the COVID-19 pandemic. CIGA introduced a new standalone moratorium option for companies in financial difficulty, giving them 20 days of protection from certain creditor actions, with an insolvency practitioner acting in the role of a monitor. It also introduced a suspension of wrongful trading measures to protect directors of companies from such claims, given a financial decline was a result of the effect of the pandemic and not a decision that they had personally taken. Whilst this suspension subsequently expired on the 30th of September 2020, it was reintroduced, given by the end of the year, it was again inevitable that the UK was going to be forced into a lockdown to halt the spread of the virus. The suspensions were therefore reintroduced from the 26th of November and are now due to remain in place until the 30th of April 2021. Furthermore, restrictions were placed on the presentation of winding up petitions, and these have been in place since the 27th of April 2020. Following 2 extensions of these measures, they are now set to remain in place until the 31st of March 2021. As a result of CIGA, a creditor cannot present a winding up petition against a company based on a statutory demand that was served between the 1st of March 2020 and the 31st of March 2021. it is also not possible to present a winding up petition between these dates based on the company's inability to pay its debts, unless you have reasonable grounds for believing that COVID-19 has not had a financial effect on the company or its debt issues would have arisen anyway. Finally, SIGA also includes provisions preventing a supplier from terminating a contract of supply simply because the customer has entered into an insolvency process unless the supplier falls within a specific exemption. Suppliers will also be banned from insisting on payment of sums falling due prior to a company's insolvency as a condition of continued supply. However, there are exclusions where these clauses form part of the financial services contract and insurers, banks, and investment firms are excluded. In addition, other existing laws were also extended to help save businesses, including a new restructuring plan, which was introduced permanently rather than temporarily under Part 26A of the Companies Act of 2006 in the UK. This was similar to the existing Part 26 scheme of arrangement in existing law, however differed in that a UK court could now sanction a plan where not all classes of creditors had to approve it. This, of course, borrows from the US Chapter 11 proceedings, where it's also known as a cross-class cram-down. This showed that the government was intent on introducing measures favourable to distressed companies. In addition, the UK introduced schemes to help suffering businesses to stave off insolvency. Whilst Julie already spoke about the furlough scheme, another one which was introduced was the Coronavirus Business Interruption Loans. This allowed UK-based SMEs to apply for loans, overdrafts, invoice finance and asset finance of up to £5 million and for up to 6 years. The government also provided lenders with an 80% guarantee on every loan and pledged to make a business interruption payment to cover the first 12 months of interest payments and fees. Turning to larger companies, support was made available through the COVID Corporate Financing Facility, which was designed to support liquidity among larger firms, helping them to bridge coronavirus disruption to their cash flow through the purchase of short-term debt in the form of a commercial paper. Furthermore, a package of support for all businesses in the retail, leisure and hospitality sectors that have had to close their doors as a result of the outbreak was introduced, as well as business rates holidays for 2020 to 2021. Cash grants of up to £25,000 per property were made available through the Retail and Hospitality Grant Scheme. The grants are available to businesses in England with a rateable value of up to £51,000. An additional small business grant offered a one-off grant of £10,000 to small businesses too that already benefit from the rate relief. Of course, it was unfeasible to allow this level of lending for an indefinite period of time, and therefore on the 2nd of September 2020, it was announced that new applications to participate in the COVID Corporate Finance Facility would be accepted until the 31st of December 2020 only. And that was subject to enhanced credit quality review processes. And also now, the Corona Business Interruption Loan Scheme is due to close for new applications at the end of this month. So what is the current position in the UK? Firstly, as I said, the temporary insolvency practice direction remains in place, as do many of the insolvency measures introduced throughout lockdown. Secondly, under SIGA, restrictions on presenting winding up petitions remain in place until the 31st of March 2021. The bar is set in establishing that a company has experienced financial difficulty due to COVID-19, but that has been proved to be quite low. So alternative procedures are typically required to be explored. Also, a suspension of liability for wrongful trading remains in place until the 30th of April 2021. In practice, it remains up in the air how much impact this has had on decisions of directors, given that they're still accountable by the directors' duties under the UK's Companies Act of 2006. Thirdly, as a permanent introduction, the Part 26A restructuring plan remains. However, it has to be remembered that due to the high costs involved, small and medium-sized enterprises are therefore unlikely to take advantage of this procedure, and therefore really it's realistically just an option for those in the upper ends of the market. Fourthly, provisions preventing a supplier from terminating a contract of supply as entered in the insolvency process remain in place permanently, but the exclusions have meant but secured creditors and lenders are not prevented from enforcing their security or terminating financial commitments upon a borrower entering into an insolvency event. Finally, whilst the Coronavirus Business Interruption Loan Scheme closed for new applications at the end of March 2021, what is new is that from the 15th of March 2021, a £20 million SME Brexit support fund was introduced to enable traders to access practical support, and that includes training for new customs, rules of origin and VAT processes. Smaller businesses can also apply for grants of up to £2,000 to help them adapt to new customs and tax rules when trading with the EU. And then on the 6th of April 2021, we're expecting the recovery loan scheme to be launched. This will mean that businesses of every size can continue to access loans and other kinds of finance up to £10 million per business once existing COVID-19 loan schemes close. But what other plans does the UK have? On Wednesday, the 3rd of March, the UK announced a spring budget for the country, and the government announced the following measures for the future. That COVID financial support would be extended by the furlough scheme being extended. This will now run until September 2021, and self-employed support was also extended with a 4th and 5th grant announced. Also, there would be a decrease in the VAT rate for the hospitality sector. This has been dropped from 20% to 5% for businesses in hospitality for the next 6 months. At the expiration of 6 months, that rate will then increase, but it'll only go up to 12.5% for a further 6 months. Next, the threshold for paying the basic rate of income tax will rise to £12,570 next year. For high rate taxpayers, this will increase to £50,270, but both rates will then be frozen and stay the same until 2026. Corporation tax will be increasing up to 25%. The rate, however, will remain at 19% for small businesses with profits of under £50,000. However, it's important to remember, despite the UK government's efforts to enable the country to come out of lockdown and return to some form of normality, this still remains hindered by uncertainty, which means that the effect of the virus leaves the country unclear as to the impact of the changes to date. The UK, therefore, still faces an unpredictable future ahead. I shall now hand back to Julie to conclude our presentation.
Thank you, Nitin. As Nitin rightly said, the UK at the moment, nobody knows what will happen over the coming months. The plan is that we ease out of the current lockdown and that restrictions are gradually eased to the extent that all social contact limits are lifted on the 21st of June, which coincidentally is my birthday, which I'm very much looking forward to if it happens. But I think no one can escape the news at the moment. The third wave that's in Europe, our Prime Minister the other day said that we're not going to escape this third wave. So what impact that will have on the roadmap that's been set out for the easing of restrictions, nobody knows at the moment. And that leads to a huge amount of uncertainty for all businesses and for employers in particular. The existing measures that we've covered today will continue, and for the majority, or certainly from the employment point of view, they will continue to run at least until September this year. There are new measures still being introduced though. On the 4th of May this year, there are 2 moratoriums being introduced, the breathing space moratorium and the mental health crisis moratorium. And they will allow certain debtors to be protected from enforcement action, essentially giving them a sort of time to resolve cash flow issues and to actually get their businesses back on track. There's a lot to be positive about at the moment. The vaccination programme, obviously the UK, we're very proud of that at the moment. We've immunised over half of the UK adult population already. So that's a great progress that's been made. But in terms of what that means in the future, the uncertainty still remains. We had this roadmap out of lockdown, and we hope that there will be some easing over the coming months. The participant who asked about vaccine passports, I think the introduction of vaccination, certainly in the workplace and for particular jobs, there is already discussion in the UK about care workers being required to be vaccinated because of the job that they do, and that will potentially roll out into other businesses. There are lots of employment related issues concerning that, not least because there will be arguments about discrimination. There are certain individuals who won't be able to take the vaccine. They may have an allergy, they may be pregnant. So that there are going to be lots of, I think, questions and certainly a lot of guidance that will be needed for any employer that's looking to introduce those vaccination passports in terms of the workplace. So that concludes our presentation for today. We'd just like to thank everybody for listening. And if you have any questions, either now or after the webinar today, please feel free to get in touch with either Nitin or myself, and our contact details will be on screen in a moment. Thank you very much.
Thank you, Nitin. Thank you, Julie, for this very interesting presentation. You have a broad variety of measures which have been imposed in the UK. Yeah, thank you for enlightening us on this. And I would like to invite the participants to put forward their questions in the chat. I will read them aloud. And we already received one question from Fred Chilton. Are international border closures permitted in EU? And in brackets, he writes, contra rules versus free movement. So maybe you could answer this question. Are international border closures permitted in the EU?
Maybe it's more of a EU question since we've Brexited, but not wishing to avoid the question. I mean, at the moment, our international, this is exactly the reason why our Prime Minister has announced that we're likely to see a third wave. It's a very fine balancing exercise in terms of why we would want we would want borders to be closed. There has to be a balance between the legal efficacy of having border closures to prevent the spread of the virus as against the impact that we would have on our economy. So it's a balancing exercise. And I think that currently the UK hasn't closed its borders, particularly for that reason, because the catastrophic effect it would have on its economy because of the movement between borders means that it's choosing not to. Whilst we anticipate that with the benefit of our vaccine program, we are absolutely en route to some kind of normality soon, because we are trying to find that balance between the economy and the livelihood of our people. We are not at this moment in time closing our borders.
Okay, thank you very much. Maybe somebody from Germany would like to add something to this question about the permittance of closures of borders. Henning, Dr. Rasner.
Well, I can say that this is, in the EU, this is a national question. This is decided by the nation and not by the EU in general. And so, for example, in Germany, you have the scheme that if there are risk areas, we would then not allow or only allow with a negative test to enter Germany. So the schemes are different within the EU. We don't have a scheme all over the EU.
Okay.
That helps.
Yes, thank you. Maybe Dr. Rasner, you would like to add something? If no, we just move forward.
No, thank you. There's not much to add, but I think the main difference, and without becoming too politically here, is that the tests are not that severely monitored in Europe and in Germany as they are currently in Asia. So that's probably the main difference. And there's also no sort of monitored quarantine where you have to stay in a hotel or something like that. There's just when you return from what classified risk area, you just have to stay in home quarantine for 2 weeks, and this is only very loosely monitored. That's maybe also one of the issues we have here right now.
And then we have another participant to remarking, not closing the borders seems rather risky, considering UK has failed to control the spread. Why is there further delays to put more risk to lives and economy? A rather provoking question. Maybe you would like to comment on this one.
I'd like to pass it to Julie, but I will answer. But I think I covered it in the last response I gave. And in fairness, that's a political question, not necessarily a legal question. As I say, the truth, and without wishing to get too political, the answer is that the politicians making those decisions are trying to find a balancing exercise between whilst we can talk about the livelihoods of people and the risk of life, equally, it's prevalent probably across the world, but certainly in the UK, and maybe Julie could touch on this, about the effect that the struggles of COVID are having, particularly on business owners and individuals when it comes to things like mental health, their well-being, and their quality of life.
Yeah, I mean, I think, as Nitin said, it's probably more of a political question. It's certainly a question that lots of people in the UK have asked and will continue to ask as well. You're not unique in sharing that view about the UK's response. They've always maintained that they're guided by the science, and I think in this situation, is there much alternative? I think you have to be guided by the people that know probably more about it than the politicians do. But I think there's absolutely been criticism. As I've said, there was criticism about the state support that was introduced as to whether it went far enough. There were too many people that were excluded from that. And as Nitin rightly said, the impact is far wider than the immediate impact. The mental health issues that have come out of just people working remotely, not interacting with colleagues. For some people, they may not speak to anybody for days, and I think that will undoubtedly have an impact. There's also the effect of what happens on general medical treatment. There's a huge backlog in our NHS now because of the priority that's been rightly given to treating patients with COVID. So I think at some point there has to be a balance, but you're absolutely right, the participant to raise it, and it's certainly something that has been said very loudly in the UK too.
Okay, thank you very much. And I think we will close the session on Great Britain now and turn to Malaysia. I would like to invite our experts from Kuala Lumpur to talk about the situation in Malaysia. So please welcome Ms. Cassandra Tomasios, partner of Ma Wong Kwai. I hope I pronounced it right. And Mr. Raymond Ma, who's managing partner also at Ma Wong Kwai and Associates. So please, the floor is yours.
Thank you very much, Svetlana, for the introduction. A very good afternoon or morning to all our attendees. A very good afternoon, yes. As a member of LAWASIA, I am delighted to be a part of this webinar, and I thank LAWASIA and the German Federal Bar for this invitation. I'm Raymond, and I'm the managing partner of Ma Wong Kwai and Associates. Svetlana, you got it quite close, thank you. Our firm was in fact established by a past president of LAWASIA, Datuk Ma Wong Kwai, back in 1985. Today, we are a full-service law firm in Malaysia, servicing both local and foreign clients. In the quick 10 minutes that I have, I'll give you firstly a snapshot of how the pandemic has unfolded in Malaysia. Secondly, an overview of the current economic situation here. And finally, a summary of some of the financial support measures provided by the Malaysian government for companies in response to the COVID-19 pandemic. Then I will pass the mic to my colleague and partner, Cassandra, who will give you an overview of the Malaysian response to insolvency and employment issues caused by COVID-19. So let's get going. This is what the COVID-19 world map looks like today, with the blue circles indicating the relative 14-day infection in each country. And that's us over here. And relatively, I think we're doing pretty well. Here's a look at total infections per country. And we can see from this that the countries in the ASEAN region are doing well, relatively well at least, particularly when compared to the Americas and Europe. So to our co-speakers in Europe, please do take care. Now let's zoom into Malaysia. We have the Malayan Peninsula on the left, and on the right, the states of Sabah and Sarawak on the island of Borneo. In total today, we have 333,000 infections, increasing at a current average of about 1,300 infections per day. In total, we've had 1,233 COVID-19 deaths. Now, the first reported case of COVID hit Malaysia on the 25th of January 2020. Our government reacted relatively quickly and implemented a strict national lockdown, what we call the Movement Control Order, on the 18th of March 2020. When infections were only about 100 plus per day. And infections generally hovered in the 100 to 200 range and didn't exceed 300 per day. And then restrictions gradually relaxed in May, and by July, things were looking pretty rosy with under 50 infections during this period. And over here in July, look at that, single-digit infections. Great work, Malaysia. And then things went belly up after the state of Sabah held its snap elections in September. So that's a no thank you to the politicians. And combined with loose restrictions over the Christmas holidays, that pushed us back into lockdown in January the 13th, when infections hit 3,000 a day, with numbers peaking just shy of 6,000 at the end of January. And as at the 21st of March, our numbers are decreasing from, as I mentioned, 1,003 per day, and we've moved from lockdown to a more relaxed conditional movement control order. Now, the COVID-19 lockdown over here resulted in empty shops, empty streets, with only essential industries and services being allowed to operate with restrictions during the strict lockdown in March, starting in March last year. Cash flow, of course, was an immediate problem for businesses in April 2020. There were supply chain disruptions, talk of bankruptcy and insolvency was quite rife. At the time, we saw a dramatic digitization by businesses, ours included, to cope with the new normal. The growth rate, as a result, suffered a dramatic fall in GDP growth to negative 17% in the second quarter of 2020. Growth was still negative in Q3 and Q4, but significantly better at negative 2.6 and 2.4 respectively. Now, to put the year 2020 in perspective, our negative growth of 5.6% was worse than the dot-com crisis of 2000 and the financial global crisis of 2009, but not as bad as the Asian financial crisis in 1998. All of our major sectors were affected, and a comparison between 2019 and 2020 shows that construction and services suffered the greatest hits. Overall, our steady growth in gross national income up to 2019 got beat back by about 2 years. Now, this slide will be of particular interest to our corporate lawyers present. I don't have the figures for Malaysia alone, but the M&A number and value in 2020 for Southeast Asia seem to have fallen to levels seen in the early 1990s. Coming back to Malaysia, although the overall fall from 2019 to 2020 was more than half, Malaysia did experience a net foreign direct investment inflow in Q4 of 2020, which was due to continued equity injections and higher reinvestment of profits. Perhaps things look relatively good in Malaysia, or investors just don't know where else to move their money to. The Malaysian government has implemented several stimulus policies for the country's economic recovery. The Prihatin Economic Stimulus Package, Prihatin meaning concern, was announced on the 27th of March 2020. It comprised funds of 250 billion ringgit, about 60 billion US dollars, being allocated to protect the people, support businesses, and strengthen the economy. A large portion of the funds under the package were allocated to support small and medium enterprises. Loan interest rates were reduced to 3.5 as compared to the usual 4 to 7 offered to SMEs. Additional funds of 50 million ringgit were also allocated under the micro credit scheme for soft loans at 2% interest without collateral. And previously, while eligibility required applicants to be operational for at least 2 years, but under the scheme, eligibility requirements were relaxed to a minimum of 6 months. Other assistance for SMEs included a tax exemption for landlords of private premises who gave tenants rental deductions or discounts, 25% reduction on levies for foreign workers, extension of time for businesses to file their annual returns and statutory documents. Government-linked companies were also involved in the granting of rental discounts to businesses. For bigger companies, the government provided a 50 billion ringgit, about $12 billion guarantee scheme for up to 80% of the loan amount for financing working capital requirements. Special relief facilities encompassed a 50 billion ringgit, about $1.2 billion fund allocation to reduce short-term cash flow problems by SMEs. Financing relief ranged up to 1 million per SME with a financing rate of 3.5%. And repayment periods are 5.5 years, including an initial 6-month moratorium period. Penjana Tourism Financing was a specific initiative to aid companies, small companies in the hard-hit tourism industry by providing financing of up to 300,000 ringgit per company for a tenure of 7 years, again with a lower 3.5% interest. The program covered the traditional hotel and travel sectors, as well as medical tourism, conferences, and other businesses who had a heavy reliance on tourists. Other additional measures introduced by the government include a 1 billion ringgit, about $250 million fund to finance high-tech and innovation-driven SMEs. These apply to a wide range of industries in ICT, R&D, and E&E, including pharma and telcos, but not legal, unfortunately. Loan moratoriums were introduced by the National Bank for the temporary suspension or deferment of loan repayments for a period of 6 months from April 2020 in relation to hire purchase and housing loans. And finally, the taxman has been generous. Help with cash flow under this stimulus package included the postponement of income tax installment payments by SMEs for a 3-month period from April to June 2020. And in addition to certain tax exemptions provided to local companies, the government is incentivizing foreign investment with tax exemptions for foreign companies that relocate their businesses into Malaysia and make investments in the manufacturing industry, with a 0% tax rate for a period of between 10 to 15 years for capital investments of more than 300 million ringgit, about $72 million. A good offer, no doubt, but while stocks last. that's it for me, and I hope you found that introduction or summary of position in Malaysia interesting. I now pass the baton to my colleague Cassandra.
Thanks so much, Raymond. Just bear with me, everyone, while I'm just going to share my slides here. Okay, there we go. So hopefully everyone can see these slides now. Okay, so a very good evening, or rather good morning to everyone from wherever you are in the world. As Raymond introduced and Lana introduced earlier, my name is Cassandra Tomasios, and I will be taking over the last part of our presentation today. Just as a brief summary of the top points that I'll be covering would be the current state of employment and insolvency in Malaysia at the moment, and the COVID-19 Act, which features the insolvency and employment matters in the country. To give a brief overview of the current pandemic, what you see on your screen now is a small timeline of the things that have progressed from January last year, 2020, up until this year. And what we've seen, as Raymond was mentioning earlier as well, is that the rates of unemployment and insolvency in the companies commenced as early as April. So from the slides, what you can see is that this ties in around the same time as the country went into lockdown. Which means that our unemployment rates and insolvency rates started to drop around the same time as MCO was implemented, which is our movement control order, which we classed as lockdown here in Malaysia. So with this unemployment rate, what then happened was that the Department of Statistics in Malaysia recorded that as of November last year in 2020, the unemployment rate went up to 4.8%. And this was in total of about 764,000 people, which was unemployed back then. Of course, the statistics for this year is not recorded as of yet. However, I envision that it will probably be increasing, and this is in line with insolvency rate as well. So the insolvency rate in Malaysia, unfortunately, there is no current statistics, which has been issued by the Malaysian Insolvency Department as of yet. However, projections estimate that the rate will be at an all-time high due to the pandemic and the economic downturn in Malaysia as well. With loan moratoriums ending last year in September 2020, what we will see then is a surge in insolvency rates. And the reason for this being that moratoriums have ended, companies will now be filing for bankruptcy. And the bankruptcy numbers for individuals essentially will mirror that unemployment rates as we've seen, as I showed you in the previous slide. Whereas in corporate, winding up for companies and insolvency, this would be largely due to our adverse economic atmosphere, which I would presume mirrors both globally and within the country as well. So what then has Malaysia done? Malaysia has implemented something called the temporary measures for reducing the impact of coronavirus disease. And this, in short, is known in Malaysia as the COVID-19 Act 2020, and even shorter, just the COVID Act 2020. And this was introduced late last year. The Act sought to provide temporary relief and recovery measures to reduce the impact of the pandemic in Malaysia. Of course, it was not an all-inclusive COVID Act, and we're still looking to amending that in time to come. It came into force last year, sometime in October, and it will be in force for a period of 2 years, and that will tie us nicely into 2022. Some features of the COVID Act included modifications to certain other pieces of legislation. Some features included the inability to claim for non-performance in contractual obligations. And this was specific to certain sectors, including construction, manufacturing, import and export industries. But overall as well, it provided a safety net for those who were unable to perform their contractual obligations due to the pandemic. And this, of course, raised issues of force majeure clauses and whether they're not in the agreement or not. But by doing so, what the government has then done is that they've taken certain pieces of legislation, which is what you see on the slides here of several different acts, some of which include Insolvency Act, the Consumer Protection Act, the Housing Development Act, Industrial Relations Act, more importantly, and the Private Employment Agencies Act. The main two amendments which I'd like to touch on for this presentation would obviously be in relation to insolvency and employment. And that relates to the acts which were amended and modifications made thereto. So a brief example of what type of modifications we made was, in addition to the employment matters, Insolvency Act was then amended to refer to an increase in indebtedness, which then saw the Insolvency Act 1967 being subsequently amended due to the COVID Act. For bankruptcy matters, they then also amended pieces of legislation which then stated that for bankruptcy matters, this now means that creditors cannot commence bankruptcy proceedings against the debtor unless the amount of debt that is due and owing to the creditors either equals or exceeds a total aggregate amount of 100,000. Essentially, what this means is that the bankruptcy threshold has now increased from 50,000 ringgit to 100,000 ringgit. And this obviously in turn offers more cash flow as well as liquidity to individuals who are struggling due to the pandemic, and which is quite large in Malaysia at the moment. And at the moment, for now, there is talks that this will be extended, but it is currently in force only until August of this year. And this bankruptcy proceedings relates more so to individuals. On the insolvency part for companies, the company's exemption order number 2 then took effect on the 23rd of April last year. Now, this increased threshold for insolvency proceedings for winding up companies, which companies were very pleased to hear because it then moved from 10,000 ringgit to 50,000 ringgit. And again, this was to offer more cash flow and liquidity to companies who were struggling to pay off their debts due to the ongoing pandemic that affected a lot of Malaysian companies. The exemption order number 2 also provided that a company will only be deemed unable to pay its debt in the event the company fails to pay the debt as stipulated under a statutory notice of demand. Now, this statutory notice of demand previously included a time frame of 21 days. However, it is now changed to within 6 months from the date of its service. So 2 things have changed here in terms of providing companies and businesses with more financial stability and sustainability. Is that 1, the threshold was increased from 10,000 to 50,000, and 2, the notice, the time frame to pay the debt and reply to your notice was now extended from 21 days to 6 months. In terms of employment stimulus measures, the government did expend quite a bit of funding into employment-related matters, and as previously mentioned as well, which Raymond highlighted, a stimulus package is called Prihatin, which was a wage subsidy program that was offered to alleviate companies' cash flow, both immediately and in the long run. And this was done to prevent layoffs and retrenchment of employees as well. The measure, in a nutshell, included an eligibility criteria to employees who earn 4,000 and below, where there was a tier to be given, and one of those tiers included 600 ringgit to be given to companies per month for each employee within this criteria for a period of 3 months starting from 1st of April. So at that point, when this stimulus package was issued, it was issued to be enforced from April, May, and June, where companies were given employee subsidy packages for those only who earn 4,000 and below. Now, the wage subsidy comes with a condition that employees must retain their staff for at least 6 months. The 3 months during which the subsidy is paid, and the remaining 3 months after that. And again, this was the government's incentive for to prevent layoffs and retrenchment in companies as well. Employers were asked to also not reduce their staff in any way, nor reduce staff salaries, nor instruct them to take any form of unpaid leave. Unfortunately, this relates more to SMEs rather than big corporations, and I'm sure this is also the case around the world for companies in the airline industry, especially in Malaysia. Employees, unfortunately, have had to take a significant pay cut, if not several retrenchments have also occurred, and forced unpaid leave as well. Just to sum everything up quickly, I'll give a brief overview. Actually, sorry, before I do that, I'm just going to go really quickly into the Industrial Relations Amendments Act. There were further amendments made to the Industrial Relations Act, and this pretty much revolved around claims. It was gazetted last year in February, and it came into partial effect this year in January, which is a good 1 year. that it took to came into effect. But pursuant to this amendments for what it was made under the industrial relations was that any employer or employee can now be represented by any person of their choice during a conciliation process at the industrial relations department level. Previously, the Minister of Human Resources in Malaysia could refuse to refer unfair dismissal complaints. And this was in the event they were of the view that they were frivolous or vexatious. However, with this Amendment Act, what happens now is that the minister no longer has this power and all referrals are now automatic, which means that referrals are automatic in terms of any unfair dismissal complaints can now go straight to the industrial court if there is no settlement made at the industrial relations department level. The COVID Act also introduced further amendments to be made under the Industrial Relations Act, which included extensions of time to file unfair dismissal representations. And this was the case, obviously, because with lockdown, people weren't able to travel up and down and it became a problem. So for the period between April to June last year, which is when our MCO and our lockdown was implemented, the 3-month period was not counted towards the deadline to file their representations. Other interesting features included the imposition of interest. The industrial court now has powers to impose an interest of up to 8% per annum, which was not there before, to any awards which was previously, to any award which is given. And again, this was not given before, so now we do have interest in addition to a waiver for extension of time for industrial relation complaints. It is also interesting to see that digitalization within the government sphere, because beginning sometime this year, the industrial court has now fully moved to allow online hearings to be conducted, which means that people in in states which are quite far away now have the opportunity to take part in online hearings by way of long distance communication technology, which is good. And I'm just going to sum up the overview by giving you an ASEAN country overview of what we have for the fiscal GDP packages. Generally speaking, a more diverse and digital economy was obviously in this day and age better able to withstand the challenges that we faced in the pandemic. Example with of Malaysia being a country is one with our high-tech industry and strong services sector. We were able to diversify ourselves a little bit more and absorb the losses due to the economic downturn. However, with that being said, Thailand's key industries were badly affected by the pandemic, and this being that they are very heavily reliant on tourism and exports, given that it was due to the closure of international travel. Similarly, Philippines continues to face certain challenges as well, as their countries imposed strict lockdown measures last year. Again, more importantly, the economy in Philippines is heavily reliant on overseas remittance, which account for about 9% of the GDP, with thousands of the country's population being overseas. Meanwhile, the dynamism of digital industries in countries such as Thailand and Malaysia and Indonesia has allowed us to effectively pivot towards digital technology, such as digital payments, e-health platforms, this webinar we're doing right now, online education services, which has also caused a boom in online retail purchase platforms, especially in Malaysia. While all countries have implemented some form of stimulus plan or state support packages, of course, each country's stimulus measures will differ significantly. As of December last year, I think Thailand's stimulus package was reported to be one of the largest, which was equivalent to 22% of their GDP. And I can safely say I'm quite happy to see that Malaysia followed closely, totaling 21%, and with Indonesia, Vietnam, and Philippines falling in considerably lower. I'd just like to end to say, if you'd like to reach out to us, these are our social media handles that you can reach out to us on. I'd like to extend on behalf of Raymond and myself a very big thank you to the organizers in LAWASIA and the German Federal Bar for giving us this opportunity to speak and for inviting us today. So thank you very much. I'll hand the floor back over to you, Lana.
Thank you, Cassandra. Thank you, Raymond, for this very interesting presentation. It was really interesting to hear what's happening in the very important industrial sectors in Malaysia. And of course, yeah, the impact is a different one if you are FDI receiving country and also depending very much on tourism, like most of the countries in Southeast Asia. It's good to hear that your government is doing something to cushion this. Very interesting presentation. Thank you again. So now I would like to invite the participants to put forward questions. If you have any, please use the chat function. And we have one. Yes, we have one from Mario Quinnett. Did the pandemic undermine the security of tenure of the employees? Please, Raymond, Cassandra, I think I understand it, even though I don't know what means the word tenor. I don't know, hopefully you understand it better than me.
So I'm happy to give this a go. I think what the question is, what they're trying to address is whether the pandemic undermined the security of the term of employees that people had in terms of their employment. It definitely did. The answer is yes to that. And the reason for this is because we saw an increase in people obviously being worried that their employment may not stay, that their employment may not stick. And this, I think, was common not only in Malaysia, but across the globe as well, with companies not doing very well. Retrenchment was high, layoffs was high. So I think regardless of the fiscal packages that I mentioned earlier, it was still predominant that some companies were doing retrenchment and were doing layoffs. So yes, it definitely did affect the security of tenures, especially for employees.
Okay, thank you very much. Oh yes, we have another question. The stimulus package is certainly very helpful to business. Nevertheless, do you think Malaysia should have made provisions similar to CIGA in relation directors' duty to prevent wrongful trading?
Sorry, Raymond, you can go ahead.
So, I was going to ask, do you know what CIGA was referring to, Cassandra?
Yeah, so I think Nitin can add there.
Yeah, I was just going to jump in there. So it's the
Thank you, Nitin.
Corporate Insolvency Governance Act. And so in the UK, Raymond, we have prevented the, we put a halt on the ability for people to accuse directors of wrongful trading, which effectively is the instance where if you have seen that your company is going into a decline, you should have instigated an insolvency process earlier. And if you waited too long, then you could be accused of wrongful trading and be held personally liable for the debts that you accrued between the two periods. Now, in the UK, under CIGA, the Corporate Insolvency and Governance Act of 2020, what we've done is we've said, because it's not because of directors' decisions, but potentially as a result of the COVID pandemic, that there's a decline in the finances of the company, that those directors shouldn't be held personally liable for wrongful trading. So that's been suspended in the UK. Hope that helps.
Thank you, Nitin.
Yeah, thanks very much, Nitin.
Thanks, Nitin. I don't think in Malaysia, correct me if I'm wrong, Cassandra, I don't think we have any specific legislation that came in since the pandemic to address this. So I think the ordinary rules against wrongful trading and the relevant laws on insolvency continue to apply. We don't have anything special to answer the question. Whether it would have been helpful, perhaps. It hasn't been, this issue hasn't been a big topic of discussion in Malaysia. So yeah, I can't say that it has been a big issue here.
Thank you very much. Oh yes, we have another question. Is the early switch to e-commerce gave Malaysia and Thailand better adaptation to the economic disruptions brought by the pandemic? And what can we say to other ASEAN countries, for example, Singapore?
Sorry, Raymond, do you want to go first?
Okay, I'll give it a go. Well, this is not very legal and luckily not political, but I think just from an observation as being part of the business community in Malaysia, I think Malaysians and particularly Malaysian businesses and perhaps even more so SMEs are fairly adaptable. So I think the digitization, while of course some business struggle, I still think occurred on a very rapid basis. So I think Malaysians and Malaysian businesses are doing relatively well. I wouldn't be able to draw a specific comparison with, say, Singapore. I wouldn't be confident of making a comparison to say whether Malaysia has outdone Singapore or the other way around. Cassandra, do you have anything to add, please?
Yeah, so I think one, I'll agree to this question in part, in piecemeal. Again, while we wouldn't compare ourselves to Singapore, I think it is true though that while e-commerce trading platforms in Malaysia lifted off quite early, I think that sometime in 2018 as well, whilst we also had cryptocurrency and financial technology lift off at the same time, it definitely did help us through the pandemic because we were much easier then to adapt moving forward. And, you know, given working from home as well, it really helped in terms of digitalization. So yeah.
Thank you very much. So because when I look at the watch, it's better to conclude the session on Malaysia now because we are a little bit behind in the time schedule. So sorry for the questions which could not be answered in live, but you are free to contact the speakers via email as they already introduced their channels of communication with them. So please contact the speakers directly for the questions which have not been answered. And now I would like to invite the speakers from Germany to give us a presentation on the situation here back in Germany. So our first speaker will be Dr. Markus Rasner, who is a partner at Oppenhoff Law Firm, to speak to us about the situation in Germany. So Mr. Rasner, please, the floor is yours.
So can you all see the screen I just shared?
Yes, it works very fine.
That's great. Yeah, thank you very much, Lana, Henning, fellow panelists, President Chong-Wan Choi and the whole organizing team of LAWASIA and PRAC for your very kind introduction, and thanks for having me. Very pleased to contribute to this panel. It's actually the second time that I speak at the LAWASIA conference. Last time still in person in Frankfurt a few years ago as a representative of OAV, the German Asia Pacific Business Association, which is Germany's strongest voice when it comes to business in Asia, where I'm still active as a board member. My name is Markus Rasner. I'm a partner at Oppenhoff, which is one of the leading independent firms in Germany with a history dating back to 1908. I'm focused on M&A transactions with a significant share of outbound investments from Asia into Germany. And I also coordinate our firm's Asia activities and personally head our China desk. And also had the privilege to spend 2 years of my professional life in Singapore. These are still very unusual times for most of us. I think as human beings, we all would love to come together and to meet at occasions such as this one, which unfortunately still is not possible. But these times are also difficult for us as professionals, in particular when dealing with cross-border matters. These deals have become more and more difficult since the corona pandemic has arrived. And this is for one obvious reason, the various travel restrictions we already discussed about, which make it almost impossible to attend management meetings and to meet in person to conduct site visits. But on the other hand, it has also become difficult because many countries, because of the pandemic, have now become aware how dependent their economies are on supply chains, and also that there is a certain lack of local production. And this is also true for Germany, in particular with regard to the healthcare industry. And this is why, apart from the obvious matter like financial aid and employment measures taken, I would also like to focus in my presentation on foreign investment control, which I also identified as, I would say, a somewhat underestimated state measure to save business, however, with a very severe impact. So the very first slide is somewhat familiar to all of you, but specifically sets out how the pandemic has evolved in Germany. The virus actually arrived at a very early stage in late January already, when a Chinese employee of a German automotive supply company attended a workshop in Munich. And that was actually the first cluster in Germany, which luckily we got under control quite quickly and also easily. And then the first massive outbreak in Germany was actually related to mostly younger people returning from Austria from their ski break. And that was spread throughout the carnival season in Germany, and actually not just in Germany, but mainly all over Europe. And that was basically a year ago. I think on the 11th of March, they decided for the first lockdown, where also schools were closed as an immediate reaction for a couple of weeks. And as we in Germany came through the first wave quite well, maybe also because we were lucky, because as I said, younger people were the main driver. I would say we were overly relaxed during summer as regards COVID. And we even had discussions whether there will be a second wave or not, or whether it's already over. And this might serve as an explanation of the situation where we're in right now, but also why the reaction in autumn, what I described as the partial lockdown, was somewhat vague. And only before Christmas, when the politicians realized that the figures are increasing significantly, a tougher lockdown has come in again, which basically lasts until today. With the main difference that schools were not closed this time as in the first lockdown, but they made use of distance learning to the extent possible. And now we are at the beginning of the third wave, with incident rates at about 120 roughly nationwide, and the British mutant counting for, I think, more than 90% of the cases right now, and even the South African mutant, which actually made my children not go into the kindergarten any longer because it was closed last week. And unfortunately, at the same time, an increasing part of the population seems to be somewhat tired of the measures, which has led to heavy debates now whether we should actually open up shops, restaurants, museums, theaters, and the like, or put more restrictive measures in place again to circuit break the upcoming third wave. And with the Chancellor Merkel's retirement, as you all know, and the general elections ahead, these are definitely going to be exciting times when you are a politician or just an observer. But that's not what we wanted to discuss here, but this is just a glimpse of where we are in Germany. On my next slide, like many other countries and what we've heard already, financial assistance is the main topic here, and the numbers are just incredible. The federal government has decided on numerous state aid measures to overcome the crisis, and they concern SMEs, MNCs, but also what we call solo self-employed. And in total, the Corona aid for commercial and professional enterprises is the largest aid package in the history of modern Germany. That's pretty clear, like in many other countries. And in addition to loans and recapitalizations, it also includes sureties, grants, and tax incentives, basically what we've heard before. As the pandemic evolved, so have the measures taken by the government. After an initial aid package last year in March, the government adopted an economic stimulus package consisting of 57 individual measures. And the aggregate of the initial measures was about 180 billion euro in volume. And according to estimates by the government, all measures in sum are likely to additionally burden the public budget with almost 230 billion in the next 2 years alone. However, and that's an interesting observation, the funds made available have so far been far from exhausted. For example, today, the competent state bank has approved more than 100,000 loans totaling around 47 billion euro from from its entire special program, largely to SMEs. In addition, the federal and state governments pledged to provide guarantees of around 650 billion euros, as well as contingent liabilities that could arise from the unlimited provision of liquidity to businesses and companies via the federal government's guarantee framework, another estimated 822 billion euros. And in order to stabilize the very important, as we all know, German export industry, the federal government is also assuming the risk of non-payment in domestic and foreign supply relationships of German companies with a protective shield for supply chains and trade credit insurance with a volume of 30 billion euros until mid-21. After a so-called bridging aid program lasting from September through December last year, they announced a third bridging aid program, which runs from November from January to June 21. And also what we call the November and December packages with another 30 million in funds. And that budget was granted in order to make up for income losses and support the culture and events sectors. And for 2021, the government has also budgeted around 334 million for pandemic management and preparedness. So, as I said, incredible figures overall, and actually difficult to follow all of these measures. And from all our clients, we know that without any support from their tax advisor or even lawyers, it's almost impossible for them to actually apply for all these grants. Then we also have made use of the so-called ESF, Economy Stabilization Fund, for Germany, and who is eligible for that aid. It's more for larger companies when two of these three characteristics are listed are actually met. As you can see, a balance sheet 43 million plus and turnover 50 million plus and employees of 249 and more. And noteworthy is that it also links to FIC, foreign investment control matters, because exceptions with regard to the number of employees are possible in those sectors which are important for German security, e.g. critical infrastructure or producers of pharmaceuticals. And that is what we are going to see in a minute when I get in more detail on the FIC matters. And another requirement is that the continued existence of these companies would have a considerable impact on the economy, technological sovereignty, security of supply, critical infrastructure, or the labor market. So very broad, as you can see. And what does the aid actually consist of? It's basically a twofold: guarantees to secure loans, which means warranties in any form for unsubordinated debt instruments and other liabilities, and also recapitalizations to strengthen equity capital, which includes, amongst others, subordinated loans, silent participations, acquisition of shares in undertakings, or acquisition of other components of equity. So I will turn to our next slide quite briefly, because that relates to, that was too quick, one back. That relates to measures taken to target keeping unemployment rates low. But Henning will elaborate on employment in more detail, so I will briefly highlight these two aspects here. Policymakers, so the short-time work frame is something which helped Germany very much already during the financial crisis. And policymakers have even more expanded and made more flexible the options for receiving short-time work benefits during the Corona crisis. At its peak, almost 6 million employees in around 600,000 companies were working short-time. And from a legal point of view, that means that the introduction of short-time work leads to a suspension of the main performance obligations arising from the employment relationship. That means that the employee is fully or partially released from the obligation to perform work, but at the same time also loses his corresponding entitlement to remuneration. And as a result of the introduction of short-time work, the employment relationship is therefore not terminated. That's the key differentiator here, but only the obligation to work and pay wages is suspended in whole or in part. And another very disputed field is the vaccination issue. There's basically no general legal obligation whatsoever for anyone in Germany to be vaccinated. I have to add as of today, because there are, of course, heavy discussions on this topic as well. And from an employer's point of view, of course, there's an interest, operational interest to vaccinate employees, particularly against the background of the third wave coming up. But on the other hand, the physical integrity and the general right of personality of the employees protected by fundamental rights oppose the exercise of the employer's right to issue any instructions. So that's the two elements that need to be balanced here. So as of now, it's all on a voluntary basis, and there is little to no possibility for employers to actually force anyone. It's up until now still an academic discussion, because as you all know, the biggest issue we have is that we sort of lack of supply in vaccination. But this might become a more heavily disputed field in the next weeks, when then vaccination will be available in higher volumes. And then finally, on the foreign investment aspects, I think as an immediate reaction last year, what happened was that Germany, which had already tightened up the foreign investment control regime before, immediately decided to take action on further tightening measures. And the focus was again on what we call the cross-sector review, which has to be differentiated from the sector-specific review, where all the defense and crypto technologies fall under, which has been around in Germany for many, many years. And also the European Union at the same time has introduced what we call a EU-wide screening system, which makes it even more complicated, because if you want to acquire a company in a certain country, they need to inform all the other governments where that business is active, and need to see whether they are also commenting on that particular acquisition. And as a general sentiment for you to know, FSC clearance has not been an issue at all in Germany, like 5 years ago even. And there have been lots of changes over the last couple of years. And there is, even before COVID, there has been lots of uncertainty on that particular field. And nowadays, the ministry takes the view that they would like to almost see any transaction which is somehow related to certain buzzwords we all know, which relate to sensitive industries such as critical infrastructure, telecom, 5G, but also healthcare. And as an immediate reaction to COVID last year, they broadened up the list of sensitive areas by adding 3 segments. And the first segment was personal protective clothing, pharmaceuticals, medicinal products, and also in vitro diagnostics. So anything you can think of in relation to how to deal with COVID. And this actually encompasses manufacturing, R&D, and even sales. So that means we are currently looking into cases where someone wants to acquire an entity, a target in the UK. And if that company has subsidiaries in Germany, which are just active in sales of pharmaceutical products, this might even trigger an FIC review in Germany. And just by the way, this is going to be broadened up even further in the upcoming weeks by including artificial intelligence, robotics, semiconductors, biotech, and quantum technology. So all these buzzwords again show up here. And what does it all mean? It means that if a non-EU buyer wishes to acquire a company in Germany, the relevant threshold is 10%. So anything below 10% is not part of the scope here. And if it's above 10 and less 25, it's only fine if it does not relate to the sensitive sectors I just mentioned. So anything COVID related, anything out of the healthcare industry is now considered to be relevant. So if whenever you want to acquire more than 10%, you already are obliged to notify the ministry, and then the ministry will probably take up that one for a review. And at the same time, another new element is that it is implemented in the law a prohibition to actually complete the deal. This is something we only knew before from antitrust clearances, but not from the FIC review control. And only if you are outside the sensitive sectors, then the 25% threshold applies. That means anything above 25% becomes relevant. And if you stay below that threshold, it's not considered to apply under the FIC review. And why is all that so complex or important? Because the measurements that could be taken by the competent ministry are quite severe, because they have got the possibility to actually wind up a transaction for a period of 5 years from signing if you have not actually filed for review, and if they have not cleared it in the non-sensitive sectors. And with the new introduction, as I just mentioned, in the sensitive sectors, you're now anyway obliged to undergo the review. So that means that there is an additional element in any transaction which might take up to 4, even more months to be cleared. So that makes it even more, let's say, complex for cross-border transactions. And this is not just affecting, as you know, incoming investment from Asia, it's all over the world. So we also have private equity players from the US dealing with the same obstacles. But as a personal statement to conclude with, we are still a very open and investor-friendly country. And the main reason why they've introduced all that is just to get more transparency on these transactions. And to that extent, it's comparable with the regime in the US, which we all know under the buzzword CFIUS, where we also want to, we want to know who's investing, and then we can review the process and ultimately clear it. But of course, it has become a new work stream for all of us lawyers whenever it comes to a transaction. With that, I would like to come to a close here. Once again, thank you very much for your attention, and happy to answer your questions, and also happy to share the presentation if that is intended. And handing back over to Lana. Thank you very much.
Thank you, Dr. Raza, for this very interesting introduction. Because of time restriction, I suggest that first we turn to our next speaker, and then afterwards there will be the possibility to have a Q&A session via the chat function, so that both speakers can answer those questions. So saying this, I'm turning now the floor to Henning van Santier. Henning is a partner at Van Santier and Schultz in Berlin, and he's also the chair of the Asia-Europe subcommittee, and as that main organizer of the session. So Henning, please, the floor is yours.
Thank you very much, Lana, for this kind introduction, and again, a warm welcome to everybody. Yes, thank you very much also, Markus, for this very good introduction, giving an overview what the German state has so far subsidized or supported and what changes are there. And you are right, there has been also a change in the screening system, so this might be of interesting actually within the EU also. So my part is rather to show you the details of the scheme of support under employment law and support under insolvency law. How is this working in Germany? Just some words. Lana already introduced myself. Our law firm was founded in 1992 in Berlin, and we have an office in Poland, so I'm also a Polish lawyer. We do full service, that means tax, bookkeeping, and business law. We have, since I'm a member of LAWASIA since 2006, that means 15 years, we have considerable clients also from India, China, and Japan, and other Asian countries. This is what we are doing. Now I come to what will be talking about: support under employment law, short-time work. As Marcus was already saying something about it, then the state support in case of the necessary quarantine of the employees. The second point will be support under insolvency law. So we also changed this law, and I will tell you there's something about the obligation to file for insolvency and changes during the pandemic, which is now happening. So just a short introduction on the economic figures. We have a workforce of 45 million people. This decrease in 2020, this decreased within the pandemic time by about 800,000. So the unemployment increased. We have also, as Marcus already said, 2.6 million workers who are subject to short-time work. So this has been a quite successful measure which we introduced already during the finance crisis, and which was helpful for German economy now. What is short-time work? The basics. The definition: the temporary reduction of regular working hours due to a significant loss of business. Short-time work may affect all or only some of the company's employees. The fact is, employees work less or not at all. This is also possible. So if this is the case, then compensation is granted. The employee can claim the compensation benefit from the unemployment insurance paid by the employer. So actually the actual work is doing the employer, the application and all that, but the beneficiary is the employee. The Federal Labor Agency in Germany is in charge of granting this compensation. The legal basis: significant and unavoidable loss of work. The employment must be continued after short-time work. So this is not a mean just to get money during this short-time period, but there must be a chance that the work will continue afterwards. And then the notification to the local labor agency is the formal requirement with some explanation on that. So what is the support? Employees receive 60% of the net pay loss during short-time work. Employees who have at least one child receive even 67% of the lost net pay. This has been somehow amended since January of this year and until December 31st, so this until the end of this year. Short-time allowance increases to 70% from the fourth month of entitlement, and employees with at least one child have even a claim on 77%. And if the short-time work entitlement is in the 7th month, it can even increase to 80 or 87%. So this so far for the short-time work. Then we have also, in case the government imposes quarantine on the employees and self-employed, there's also measures to get support. When the state quarantine because of the coronavirus, there is a claim for compensation for the loss of wage, and this is for employees and self-employed. A requirement is a person is restricted or isolated by the government as an infectious agent, and work in home office is not possible, or not reasonable for the employee. So the state support would be the first 6 weeks would be a full amount of the loss earnings is granted. And then after that, up from the 7th week, it's only 67%. So far, this are the support schemes for employees. Now I come to the insolvency, the changes of the employment insolvency law in Germany. So this applies, that's the general outline of our insolvency law is, I'm just sticking to these insolvency of limited liability commercial companies. In case of the inability to pay or over-indebtedness of the company, then the managing director is compelled to file for insolvency. This is a general rule. I suppose this is in most civilized countries the case. This has to be done within 3 weeks after the circumstances of over-indebtedness or inability to pay are obvious. So normally there is the liability of the managing director towards the creditor of the company, and also he could be charged with criminal persecution due to delayed filing of insolvency. That means within 3 weeks he has to do this. So this has been changed. There had been the feeling that the obligation to file for insolvency should be reduced. So in March 2020, the German government initially provided for a suspension of the liability-based and in some cases penalty-based insolvency filing requirement until September 30, 2020. The suspension applied only to cases in which the inability to pay or over-indebtedness was based on the consequences of COVID-19. So the normal insolvency situation was still valid. Then this time limit, September 30, was extended to December 31st, so the end of last year. And now it's extended until April 30, 2021. So the obligation to file for insolvency is reduced. It's under certain and limited circumstances only possible now. There is no obvious pointlessness of obtaining the financial aid. So during the time that insolvency has not to be filed, of course, the company can ask for financial aid, but if this is in vain, then insolvency still has to be filed. Insolvency is only due to the COVID-19 pandemic, so it can't be out of other reasons. And there must be a realistic prospect of eliminating an existing insolvency. It is also considered that this sort of reduction of the obligation to file for insolvency will be extended, but the government hasn't so far decided how. This is the question of insolvency, and if you have any questions on that, I'm happy to answer that. Thank you very much, and I give back to Lana.
Thank you, Henning, for this very interesting presentation. And now I'm turning to the floor questions. So do the participants have any question? If yes, please put them forward through the chat. I will read them aloud. We have no questions on Germany right now. So maybe somebody from the other speakers, panelists, have some question they would like to put forward to our German speakers.
I think there was one question on the from the Philippines on whether offshore workers get short-time work compensation in Germany. It was from Samantha in the beginning. And no, they are not entitled. So if you're not living within Germany, there is no right to receive compensation, if I may add that.
Sorry, I must have overseen this, but
it was in the beginning.
Henning. So are there any other questions?
Lana, I just have a comment really. I think it's interesting how Germany has approached the support for employees and how you have differing levels of support depending on if you have children or not. And I think there's quite a few people in the UK that would find that quite an interesting approach, because it's certainly not something that is addressed at all in any of the support measures in the UK. But that was really interesting. So thank you both.
And Lana, if I might just add and echo what Julie says, as long-standing LAWASIA members, both Henning and I have often had this discussion about how things will change after the UK leave the EU. But I'm glad to see that even things such as our wrongful trading laws are very similar in the approach that Germany has taken, in the same vein as the UK, not necessarily making directors personally liable as a result of the COVID-19 pandemic.
Sure.
Thank you. We have one question. May I know who bears the burden of providing that insolvency was not caused by the pandemic?
Well, in the first, so it should be, the support should be given in a quick way. This means for the financial support in terms of insolvency, you would first rely on what the person who files for insolvency is asserting, and then it will be scrutinized by the court, and then the court will decide whether to open insolvency or not. So it's in the end, it's first of all the person applying or filing for insolvency has to show the reasons, and then it will be scrutinized by the court.
Okay, thank you very much. And I see there are no further questions. I would like to turn now to China, to our last jurisdiction, but certainly not the least jurisdiction. It's so big and doing so well that it can just not be ignored. So I invite Mr. Zheng Wang, founding partner of Beijing Global Law Offices, and to give us a presentation on the situation of China. Please, Zheng, the floor is yours. Unmute your microphone.
Thank you, Nana. Let me share my slides. Is it okay now? Can you see my?
We can see.
Thank you.
Maybe you can put it on the full screen mode.
Sure. It's great.
Perfect.
Thank you. Okay, good morning and good afternoon. Let me share some information about the pandemic situation in China and measures taken here, especially under the insolvency law. I enjoyed the panelists talk very much. Some information here may similar to my co-panelist. I will do that part very quick. If you have any questions, I will be very happy to answer it. Well, the pandemic situation in China, what's the current situation now? I'm going to give some short report on this part. Then the capital city, Beijing here, what's the news here in Beijing, whether Beijing are still taking some restrictions. In my second part, I will talk about on this. Then the China's the top strategy of China to control the pandemic is the vaccination. Vaccination is the top strategy now. Then I will say a few words about the new travel policy, especially for the international travelers. China is working on that part now. The current situation in China from this map, you can see the map of China. The blue part, blue is the major part. You may see there's almost over 30 provinces here. There's no cases anymore. By Tuesday, 2 days ago, Chinese mainland report there's no new cases on Tuesday. But for the imported cases in Chinese mainland, there's still total 10 cases. 10 cases on that day, bring the total number is 5,221. Up to now, of all the imported cases, 5,065 has been discovered. The capital city, Beijing has taken some restrictions to control the pandemic. Now the city government has lifted some restrictions. For example, the city has resumed the cross-city online car hailing services and as well as taxis. This is very important for people who travel across the cities. Another good news is after March 16th, there's no need to check nucleic acid test results if you travel to Beijing. Before that date, you need to show that test result if you travel to the capital city. The conferences, especially some conference, the volume, let's say larger than 100 people, now it's permitted. Some sports event is also on the schedule. They are going to, for example, in some museum, in some there are some sports news already. For the general office buildings, like the building our firm is located, when the people enter into the building, you can only scan a QR code of the mini program to report your health information. That will be enough. So the restrictions here is only for most parts of the city. It's only a small one, that is to scan your to report your health information by scanning a code to send your report. That's very easy. The current strategy to respond the pandemic is the vaccination. The vaccination, you can see the numbers here. China has administered over 82.84 million as for this Tuesday. You can look at the picture. This is a city resident. She's receiving a shot of COVID-19 vaccine in Beijing here. More and more people have taken this vaccination. People are quite confident now. The government is also actively making some new policies concerning the international travel, because the government has launched 2 weeks ago that it will launch certain certificate for the international travelers. You can see the picture in the capital airport. There are passengers line up for check-in. More and more travelers now can take a plane to take the visit here. Insolvency law, there are some new measures taken here in China. For example, the business, if the business want to file certain application for the insolvency, there's a special policy for certain cases. For example, our Supreme Court, they say there are certain measures to solve the problems, solve the cases. Under the pandemic, the court's scrutiny of the insolvency caused to be more prudent. In the counter, there are certain other countermeasures too. The conversion of the insolvency procedures under the pandemic is more flexible. You can file your applications online, or you can send your applications by email. Yeah, you can. Last April, the Supreme Court issued a judicial opinion on the promoting efficient trial of insolvency cases according to law. You may know that in China, Supreme Court's opinion is very important. It's kind of interpretation of law. All the levels of Chinese courts follow such opinions. The one we are talking about is the one from Supreme People's Court. This opinion is specially designed for the insolvency cases. After several weeks, last May, the court, there's a new regulation again about the bankruptcy cases. This is this document is called the guiding opinion on the concerning the proper trial of civil cases during the pandemic. This also provides corresponding provisions for the bankruptcy cases. In this opinion, we can see the Supreme Court want to speed up certain procedures when the offline trial is difficult. The court doesn't want to stop the work. They want to do some work online, things like that. I think these are the general lines I want to share with you. If you have any questions, I will be happy to answer later. Thank you.
Thank you very much, Zhang Zhe, for this interesting presentation. I will hand over directly to Yongwen Li, who is partner of Yinke Law Firm, a very big Chinese law firm. Please.
Thank you.
Yongwen, the floor
Thank you. You hear me well? Okay.
Yes.
Okay, thank you. So yes, dear colleagues and friends, good morning, good afternoon. Hello, everyone. A very brief introduction of myself. My name is Henry Li. I am a partner of Yinke Law Firm headquartered in Beijing. I am a transactional attorney by training. My main practice is foreign direct investment, cross-border M&A deals, and cross-border entertainment matters. Our firm, we are one of the largest law firms in China and in Asia as well, with over 10,000 attorneys in 88 cities in China and 7 offices in the United States. Our firm practices in all areas of laws, so please feel free to reach out to me if you need any assistance in China for anything. And I also would like to take this opportunity to thank the Organizers Law Association for Asia and Pacific, and also the German Federal Bar for inviting me to this wonderful seminar. It is such an honor to attend this webinar and discuss with all of my fellows. So in my presentation, as one of my peers just introduced the general situation in China at this moment. So in my presentation, I'm just going to talk more about the coronavirus aid and stimulus measures taken by the Chinese government. And I will focus particularly on the efforts undertaken by the government to address employment-related issues during this major public health emergency. So as we all know, China was the very first country to be hit by COVID-19, which later swept the world. In early 2020, it was the first time that the Chinese government had to tackle the novel coronavirus problem and address the new challenges caused by it. there was no lesson to be learned. Among these challenges is the treatment of employment relationship under such extraordinary circumstances, balancing employees' interest in job security against the financial difficulties confronting companies, and particularly small and medium-sized companies, in keeping those jobs. So in the very early stage of the pandemic, the Chinese government has recognized that the coronavirus will take a heavy toll on the job market for sure. So as such, in January 24, China's Ministry of Human Resources and Social Security, they kind of issued the notice on properly handling labor relations during the pandemic of new coronavirus infection, and issued some regulations and policy guidance to address employment-related issues under these extraordinary circumstances caused by the disease. And those rules and policies are for local labor authorities to follow as well. So this is a general introduction, what happened there, as we all know. And I just would like to talk about a few observations of the measures taken by the China's central and local governments relating to the employment matters. So first of all, the Chinese government has responded, I will say, very quickly. So here's a general timeline show that what the central government has taken. Actually, in mid-January, 2020, the China's National Health Commission first confirmed that this novel coronavirus could spread between people. A few days later, like technically 3 days later, on January 20, the Chinese State Council convened an executive meeting to plan for nationwide prevention and control of the disease. And then another 3 days later, on January 24, which is also actually the Chinese New Year Eve, China's Ministry of Human Resources and Social Security issued the administrative notice, as I just mentioned, to protect employment relationship during the pandemic. The central government has also authorized the local governments to extend the Lunar New Year holiday by a few days and place some certain restrictions on how and when the employees are allowed to go back to work. These measures taken by the central and local governments have very successfully contained the further spread of the disease. It should be noted that at the time, it was a Chinese New Year holiday. It's a very traditional holiday in China, and the tradition is that most people will travel back to their hometown, mostly in the countryside, to observe the holidays with their larger family. And after the holiday, about 1 billion people were just about to return to cities for work. And at the time, the government made a very challenging decision to stop these 1 billion people from leaving their home and canceled millions of trains and flights. So without such fast action, the spread of the virus will totally be a disaster, and the world could be totally different by now. So from late January to early February, the central and local government authorities issued thousands of administrative regulations and notices and provided policy guidance on issues, including how to pay remuneration to employees during the extended Chinese New Year holiday, how to compensate employees who are under self-quarantine or who are unable to return to work due to this kind of quarantine measures, and how to treat employees who are diagnosed with COVID, and how to use the paid leave during the pandemic, and also the requirements that the companies must fulfill before they are allowed to resume the operation. So at the same time, the Chinese judiciary has also played a critical role in protecting labor relationship. In early February, the Supreme Court of China issued several guidance documents on the trial of employment disputes, which was implemented at a very early stage, even before any cases relating to coronavirus was actually filed. Because of that, because the Supreme Court made this very early rule, the lower courts all around the country and arbitration tribunals all around the country would be able to apply a more uniform standards in dealing with and deciding similar employment disputes caused by coronavirus. And secondly, the Chinese government has taken a kind of even-handed approach towards employer and employee relationship. recognizing that the interest of an employer and also the employee, they do not always align, the Chinese government never aims to protect solely the interest of the employees. The Chinese labor law actually traditionally provided more protection for employees, as we all understand employees are considered more vulnerable. And this is particularly true during the coronavirus pandemic, as the employees could lose income altogether. But to protect the interests of the employees, the government has imposed several restrictions on companies during COVID. For example, companies shall not terminate any employee who cannot, because they cannot return to workplace on time due to the COVID-19. And companies shall pay remunerations to employees who are under self-quarantine, who are not able to work because of the quarantine. And also employees will receive medical treatment, should receive sick pay by the employer as well. These are kind of restrictions and burdens on the employer, but at the same time, the government has also taken measures to protect employer, especially small and medium-sized companies who are surely to be adversely impacted by the pandemic as well. For example, some of these measures include that the law is allowing the companies to renegotiate with employees to reduce salaries, which are normally not allowed under normal circumstances. And also the employers are allowed to ask employees to take advantage of the unused paid leave first if the employees cannot return to workplace on time. And also if the employee is unable to return to work, has exhausted all their paid leave, the employer actually may pay them what they call a leaving fee, which is kind of like a percentage of the minimum wage of the city instead of paying the full salary for. And also the companies, for companies that are required to work during the pandemic, mostly emergency services or some important business supporting business. They are kind of exempted from paying overtime payment, and instead they may negotiate with employees to adopt kind of shift schedule or to reduce their working hours to compensate for their overtime work, which will also save a lot of costs of employers. The Chinese government overall has balanced the interests of the employer to continue operation, right? And also, which also is actually protect the interests of the employees as well. So we believe these kind of measures taken have kind of paved the way for China's quick recovery from the pandemic and also the economic rebound. And thirdly, in light of the employment-related issues arising during COVID, the Chinese government decided not to pass new laws, but to instead issue administrative regulations and policies and judicial opinions under the existing legislation framework. As such, China could avoid the very lengthy lawmaking process and was able to take action as quickly as possible. As I was saying, the very first measures was actually taken just a few days after the knowing the coronavirus thing. The measures that, as I was previously mentioned, such as adjustment of wages, use of paid leave, or changes in shift schedules, should the employee not able to resume work, were all adopted kind of under the framework of the existing labor law, so there was no need to pass new laws. Another perspective, another observation is that the central government has actually only provided very general guidance on how to protect the employment relationship during the pandemic. And that was done in purpose because it allows some flexibility in local governments to find their own solutions that are most appropriate to their own situation. China is a very large country, comprised of thousands and tens of thousands of cities. As the severity of the pandemic vary really from place to place and vary from time to time, the ability of local governments to issue regulations that are tailored to the local needs will ensure the local companies and local workers benefiting from the policy that best suits their needs. And last but also not least, these relief measures taken by the Chinese government is more, we believe, is more precise and cost efficient. Instead of offering some direct cash relief for individual citizens or some loan programs for small business, like what the US government did or some other countries did, China's relief project is more like targeted. For example, in some cities in Beijing, employees, they actually receive vouchers, which could be used to make purchases at supermarkets or restaurants instead of being paid cash. There were also various of relief programs for employers, and for this kind of relief, they really had to apply and satisfy the specific requirements in order to receive those benefits. And this kind of benefits, including, for example, employer may be eligible to some of the rent abatement. There are some tax breaks, and there are also some subsidiaries, including some position subsidiaries, social insurance subsidies, refund of some unemployment insurance to companies facing operation difficulties, one-off social insurance subsidies, and some free occupational training to be provided by the government as well, to name a few. As employers have to meet certain requirements to receive each of these benefits, this ensures that only the company who actually needs the relief will receive it, because there are definitely some companies actually, unfortunately, are benefiting from those pandemic as well. So thanks to all these kind of efforts, the Chinese government was actually able to maintain a relatively low unemployment rate during the pandemic. The official unemployment rate in China remains steady and usually hovers around 4%, while the jobless rate did increase from 4% to 5.8% during the first quarter of 2020. This number is still considerably low when comparing to, for example, the US, which soared to 14.7% during the same period. And as the Chinese government has taken pretty fast, swift and action to fight the COVID situation, it has successfully put the situation under control in the summer of 2020, when most companies have since been able to return normal operation and employees are able to return to work. So furthermore, as Chinese people, traditionally we tend to save money, even if some of our people were not able to get to work during pandemic, they are like more likely to survive without satisfying the quality of life, because the pandemic only actually hit the country for a few months. And so also we believe that the lawmakers in China will actually learn some lessons from this pandemic as well, and kind of improve the current labor law scheme accordingly. So before the pandemic, Chinese employees are very likely to work from home when compared to employees in the Western world. But now that the Chinese companies realize that allowing employees to work from home or remotely may carry certain benefits as well, remote working may become more popular in China after the pandemic. And this means that the Chinese labor laws really need to be adapted to the new situation. For example, the current labor law requires the parties to actually specify the workplace location in the employment contract, and any change to that will be treated as a material change to the employment contract. And also, currently, employers are prohibited from paying social insurance or housing fund for remote workers working in a city different from where the employer is incorporated. All of these are encouraging companies from using remote employees. And also, the law is unclear on how to ensure personal safety of remote workers, how to protect intellectual property rights, and how to compensate such remote employees for work-related injuries. We believe all of this may lead to some more change after the pandemic. And another example is that the standard working hours requirement under the current labor law have kind of forced most companies in China to pay salaries, monthly salaries. This is different from some other jurisdictions which allow employees to be paid more flexible by hours. As companies have to pay most of their employees a monthly salary, this actually caused considerable financial pressure on companies during a major public emergency such as what just happened. many companies are also very less likely to make new hires even after the pandemic in light of those monthly payment arrangements. And as these issues have become like more evident during pandemic, we are all expecting that the Chinese legislation will also take some heat and we kind of reform or modern the labor laws to provide some more flexibility in employment relationship under this new world. So yeah, that's about my presentation. And again, I would like to thank the organizers for inviting me to this wonderful event. I have learned a lot from my fellows here as well. And of course, if you all have any questions at all, please don't hesitate to ask. I will be very happy to take any questions after the event as well. Thank you.
Thank you very much, Yongwen. And yeah, it's very interesting to hear that you actually have the same discussions, and as we have on labor law, we also discovered that home office is possible, not only in the startup industry. So this was the big development, or the big thing that was discovered in the past year. And there was even a claim, or there was a project where people tried to put up a project to implement home office claims into the law, so that every employee could claim, like, for, let's say, several days of home officing within a month. Yeah, and unfortunately, this project did not succeed. It didn't go through, so we didn't put it down in the legislation by now. But of course, all the employees are free to offer this as a benefit to their workers in their companies by themselves, so without having a claim even in the laws. So, but this is definitely a very interesting development, which especially the younger generation is very happy about, because it is adding flexibility and efficiency, and yeah, it's a new trend. You could say it's a new.
I think that's one of the good things came out from the COVID. The situation is actually kind of pushing the legislation to be more adapting to a more modern world.
Yes, it's true. It's totally true. Yeah, thank you again. And now I would like to hand over to the participants, actually. If you have any questions to our speakers from China, please put them forward into the chat. I will read them aloud. And of course, also the co-speakers are invited to comment or to put forward questions if they have any.
Hi, Henry. Perhaps I can start with the question, Anna. Henry, you mentioned earlier that there were relief programs available to businesses, such as subsidies and tax breaks. My question is, were these done at the national level or at a provincial or county level, given that China is such a big nation?
So mainly, I mean, the country level has provided some general guidelines, and they were saying that available subsidies to the companies would including tax break, would including subsidies. Subsidies should be used more for training the employees or switching their workforce to be adapting to the COVID, or those kind of guidelines. And then also from the central government, they allocated the budget to the local governments to use the fund. And it will be depending on the local government to decide how to use those funds more exactly. Because, for example, in some of the cities, they believe that, for example, the restaurants industry is more impacted, or for example, they believe they should use the time that the employees are at home, not working, to take some more occupational training, so they can use that for that as well. And in some other cities, they believe the manufacturer industry was more affected, and they are allocating more subsidy to those. So generally, as I was saying, we believe this kind of way of allocating the subsidy is more efficient and effective, and can be tailored to the needs of the local situation. So saying China is such a big city, and the situation in some different places are kind of very different as well.
If I may add a question, I understood that there have been about $500 billion spent to somehow safeguard the losses of the pandemic in China. And I understand it is the government who provided guidelines. Is there a claim from companies or workers or from the private side to get some of these funds, or does the guideline mean it will be the governmental entity, be it the province, be it the federal state, or be it the very low level or the local level, who just will disperse it, who will just assign the funds? Or is there a right from the other side, from the private sector, to have these funds?
So the funds allocated by the country was actually most of the funds. There are some national programs, for example, the tax break, those kind of programs are nationwide because of the tax authority, the centralized authority. Most of the other subsidies were actually funds were being allocated to the province level of government, who will determine and manage and administer the use of the funds. They have been using that, for example, to relieve some of the social security contribution. They have used some of the money to refund some local tax paid by the companies. They have used some of the fund to provide PPE stuff to the companies, mainly being used by the local governments. And essentially, as I was saying, it's one thing very different from the programs in China is that either the state, the country, the central government, now the state, the more local governments were giving cashes out. There was actually no program giving cash to individuals or to companies. Those money were spent in a more complicated way, and the government has believed that will be more efficient. For example, as I was saying, there actually will be some, for example, some vouchers given to a lot of employees and unemployed people who can use with those business, and the business can then use the voucher to claim some money back or some refund from the government. And that can, on one hand, help the employees to improve their life quality. On the other hand, kind of help the local business as well. And same with some reimbursement of employee training, and also some refund of social security contribution. All of this has been the funds. There are really a lot of money being spent for government subsidy, and the money has actually been used in quite a complicated way, divided into many localized and small programs targeted to different types of business and for different purposes. Thank you.
Thank you. I think we received a question to the German speakers. I will read it aloud. In Germany, steps have been taken in recent years to digitize the courts, the legal profession, and in certain areas of the civil proceedings. For example, section 128 of the Civil Procedure Code allows certain court hearings to take place in the form of video conferences. The pandemic has accelerated these developments in Germany. Is there a comparable adaptation in China in response to the pandemic? Oh, sorry, it was a question to the Chinese speakers. Sorry for that. Maybe Mr. Wang can answer this question. Mr. Wang, do you have any procedural sections which allow the digital court hearings? I think there have been very great developments on online courts in China.
Yes, but sorry, I didn't follow. Didn't follow the question. I thought that was for our German colleague.
Yes.
So
I can repeat
I missed the first part. So
I can repeat.
Will you say that? Yeah. Yeah.
It's basically they're asking whether there have been some changes to the civil proceedings code, or if there is in the law a possibility that you have digital online hearings and online proceedings in civil law.
Yes, but I don't think that's our civil civil law code. As you just mentioned, we have internet court, and for some other general court, they are online hearings. Actually, online hearings is quite popular here. Many people really like that. On the other hand, the arbitration committees also have such online hearings. People simply log on the computer and take part in the hearing. I mean, both for the civil courts and the arbitration cases. Yes, it's quite popular. But I don't think there's a national legislation on this regard. But there are some rules or regulations for the online hearing announced by the arbitration committee and our Supreme Court. That's the rules or the guidance for the online hearing, but it's not the real legislation. Yeah.
Thank you. Thank you. Maybe Yongren, you want to add something to this answer?
Yeah, yes, I agree. I mean, essentially, even before the pandemic, we see the trend that the court system was trying to be more adapting to the internet world and do some remote hearing as well. But was like before the pandemic was really more on a very occasional basis. And for example, in Beijing, there was internet, what they call it, internet court, and some cases assigned to the court and allowing for remote hearing. But at the time, that was only a very on selective cases. After the pandemic, it kind of becomes a must. And I will say actually the court adapted kind of rather fast. I remember that a few weeks after the pandemic happened, we were already attending hearings online, those kind of similar to Zoom calls. Yes, I also agree with Mr. Wang. There's actually no change to the civil procedure law of China. Is because it's mainly like how the hearings were held and also how the attendance was administered. Is more like local court rules. So each of the local courts make their own rules, and they were able to adapt pretty fastly. One of the issue we encountered at the beginning, which is kind of problematic, was that at the beginning, we see that different courts have been using different softwares for online hearing.
Yeah.
And every time, we have a case, we have to figure out like which exact software we have to use. And once we have like 3, 4, 5 different software for different court hearings in different cities or different places. But then later, with time going on, they have been trying to merge those systems together and to build a more unified online court system. And we believe it has been quite successful. And as Ms. Wang was saying, as attorneys, we kind of hope that can continue even after pandemic. That really saves us a lot of time and saves the time of the judge as well on a lot of cases. Especially there are really a lot of cases the judge will be mainly ruling on the paper. The hearing was not like super important comparing to the others. And for those kind of cases, this kind of remote appearing, we believe is actually kind of something should continue.
Thank you very much. I think this topic is very interesting, and it's easy to fill. It's very easy to fill another whole event with discussing this, and also with actually taking a look at what developments have been done during the pandemic in this field in each jurisdiction. And I think that China is has been taking off very early with this, and they are now very much ahead of the situation in Europe, where we are still figuring out even the ways how to communicate in a safe way between courts and lawyers. So, but it would be very interesting to have a deep dive into this. Maybe we can have another event in the coming weeks and months. And because we are now already overdue for 20 minutes, I hope we didn't lose too many of our participants, but it shows also that the event has been very interesting, and that discussions have been also interesting. So, but now I would like to come to the conclusion of our event, and I would like to hand over to Henning again for giving us some closing remarks. Please, Henning, the floor is yours.
Thank you very much, Lana. Thank you very much for this very good moderation. It was very smoothly and well done. And thank you also for LAWASIA for making this possible. We had more than 100 participants, so we can be happy on that. Well, to conclude on the subject matter is a bit difficult because the point of departures are very different. I think what we can say is that some countries spend more money, some less, but all in all, the economy was still working, and it has been paid attention to the needs of workers and to the companies. So I think this is also a lesson which is very interesting. And other than 100 years ago, when there was a big financial crisis and there was not so much knowledge how to handle that. So I think in overall, one can say this. In China, it started, as Henry said, and China is probably the first to get out with a different scheme, apparently, so rather government-driven. Not driven by those being needing like companies and workers, but also taking attention to the needs, of course. So this is also one difference, I think. And other than that, we have learned, I think, a lot of different schemes and measures that have been taken. And this is food for further discussion. And this is only 1 minute we have right now to hold this sort of situation before us, but it's not over so far, but I think we can be very optimistic to handle that. And then having learned lessons, and I think the bottom line is homework is getting more usual, and so things will be changing. This is all from my side. Thank you very much for all participants. Thank you very much for the speakers. Also, this was very, very insightful for the preparation. Thank you for the moderation. I don't know, Lana, you want to say something again, or shall I?
Yes. I
Thank you very much.
Have a short remark, or I just would like to draw the attention to the upcoming events LAWASIA is planning in April. So to all participants, on April the 8th, there will be a human rights webinar. And on April 12th, there will be a webinar on unicitral rules. So they're both organized by LAWASIA. And as usual, you will have a lot of interesting experts presenting to you. The registration is possible as usual through the website. And yeah, that is all that remains for me to say. And of course, I wish that you all stay healthy, and I hope to see you all again, either in one of the webinars, and maybe, who knows, even in the LAWASIA annual conference, which will be held in the end of this year. So yeah, goodbye to everyone, and hopefully see you soon. Bye-bye.
Thank you.
Thank you.
Very much.
Thank you. Bye-bye.
Thank you. Have a great day.